launch of this program, and thank you all the participants today who are here. Um, as we have seen over the last possibly a decade or 2 decades, from the beginning of the 21st century, I would say, we are all into digital age. If I go back in a history from Stone Age, the Industrial Age, the Electronics Age, we can qualify this as a digital age. Today, most of our daily life revolves around mobile phones, internet, social media, e-commerce, and a variety of services that we are availing digitally. And it is possibly difficult to imagine our lives without these as we go further and further, with more and more digitalization happening in the government sector, in the private sector. And what this has done is fundamentally 2-3 things which it has created. First of all, the boundaries of jurisdiction evaporates. One can be sitting in somewhere else, and like we have seen in the bitcoins today, wherever it is, you can buy it here, sell it somewhere, cash it. Of course, it comes with its own challenges and other aspects of it. Second point is, what are the legal regulatory regimes which govern these digital aspects of life? We have seen defamation in social media, we have seen cyber crimes, we have seen cyber stalkings and various other forms of crimes also increasing day by day in today's digital world. Even, for example, today I read in the paper, one of our own Indiranagar resident, who happens to be a film actress, has filed a IPC police complaint in Indiranagar police station because she got a lewd message in WhatsApp from son of Mr. Prasad Bidappa. This is very much in the news today. So you can imagine, and he has been charged under 3 IPC sections within that, and he has been assigned to the judicial custody. We can see how the whole digital world is affecting our lives. When we talk about existing life, we talk about all these things. Similarly, we have 2 lives. One is a physical life, which we all know will come to an end at some stage, and maybe depending on the person, he or she may say, donate my body after death to so and so purpose, maybe organ donation, maybe body donation, or somebody says just burn me or bury me, depending on the religion and the customs that exist in whichever part of the world. But what we forget is what happens to our digital persona, which exists in variety of digital world. We have maybe multiple email accounts, social media accounts, e-commerce accounts, government accounts. Income tax filing today is possibly virtually nil in physical form. You have to have an email ID, registered mobile number for which OTP comes to you, and even refund communication comes to that. Banking interactions are all digital, and without OTP and mobile phone, you can't even operate your banking. But thanks to all these digital technologies in the physical world today, definitely over the last 2.5 years due to the pandemic, we have all been able to do many of such transactions, including buying our daily needs, food, milk, coffee, tea, whatever it is. While the benefits are always seen, but then what happens after our death to all these interactions? First of all, in my experience, even though I keep telling, make a will. First of all, many people don't even think about doing a will. Even after I have conducted several presentations, several kind of information sharing sessions to many of my own friends, families, it's a kind of a mindset. Why should I do the will? Am I going to die tomorrow? We don't know. We have seen 2 Today's newspaper carries Shane Warne at age of 52 in a territory which is not his home territory. He passes away in Thailand. Rodney Marsh, another great cricketer, passes away within few hours of Shane Warne, which he has posted RIP in the social media without possibly imagining that he would be into that. So the life has become very, very dynamic and we can't predict what happens. So first of all, even to do a will for physical assets, financial assets, movable assets, immovable assets, that itself is a big mindset. Even after one decides that I will make a will, I have seen some people take 3 months, 6 months, 1 year, even compiling their own inventory of assets. Today, assets are scattered, possibly in multiple geographies. It may be in the same country, may not be in the same country. With so much globalization of movement of people, the assets are distributed. And we have seen, particularly for even physical assets, in places like Bangalore, if you want to transfer a property after the death to the beneficiary, even if it is willed, first and foremost they say, is this a will, registered will or not? If not, you have to get a probate done in the courts, and then you bring a family tree, you bring a succession certificate. The beneficiaries will keep running behind the courts 12 months, 18 months, and many of the beneficiaries may not be in this country. Children may be in some other country or some other geographies where they find it possibly not worth spending that much time and effort in going through the court procedures. Even when existing court procedures are there, this happens. When we come to digital assets, let me define what do we mean by digital assets. In today's this thing, apart from all the examples I gave, even a file which is stored in your mobile phone, a picture stored in your mobile phone is a digital asset. In a very simple, common man's parlance. I may contain an Excel sheet containing all my names, addresses, contact numbers, telephone numbers, emails of all my friends, families. That is also your digital asset. From as simple as that, or you would have recorded a voice, or you have spoken to your family, which is recorded in Zoom or any such online media, is your asset. On to the other extreme, suppose there are people who have created intellectual property on the digital world. I may have created an art, I may be a musician, I have been teaching online, I record all that. This all belongs to copyright to me. Or somebody is writing books, digital blogs, digital articles, they are all assets of the. Or somebody writes a very interesting newspaper article I read few years ago, which is written, somebody is writing an AI based algorithm code, software code, which he wants to transfer to his successor, his children after his death. Or somebody is recording all their vacations with family and friends and children when they are young, which they want to pass on, store it in a memory card, which possibly can retain for 50 years, 100 years, depending on the age. They want to transfer it to somebody. Who are the beneficiaries? So how do we deal with this kind of? And then we have service providers. All of us are known to just browse through. Whenever we sign up to a new account, we'll just browse through saying, okay, accept, or I sign up, I accept for the. I don't think we have time to read that. Secondly, it's not in a very friendly manner of the consumer or the user to understand the legal terminologies. If you go to the terms of service in Yahoo or Gmail, it runs into many pages in a laptop. Forget about in mobile. And the terms of service is a contract between user and the service provider. And there are a lot of constraints, lot of recordings saying that if you allow third parties to access your account, all your rights will be terminated. And all this data, to the best of our knowledge today, resides in outside our country. And California particularly, if you take the Gmails or the Yahoo or the Facebook, is one of the stringent regulatory regime when it comes to passing off any data that is held in these service providers. Very complex. California Communications Act and the US Acts, etc. Very complex to get. Whether only the header information or the contents. Contents comes into picture. Another aspect of privacy. Suppose the person is in some personal communications, he or she doesn't want to part with that information to even to beneficiaries, even to successors. So how should this be handled? There are complex environment on which we are operating. Second is one, when physical assets and tangible and intangible assets itself is not able to inventory, how do you inventory the digital assets? What are the complexities that you go through? And then other assets are accessing all these service providers. They're all yours. Your user IDs for internet banking, mobile services, electronic depositories, stock, shares and stocks that are held. How do you transfer? If you see the depository statement, even in India, even the equities or stocks that you want to transfer to beneficiaries, there's a process. You have to fill up the nominee, you have to fill up this thing, then that nominee has to have depository account, then there's a death certificate validation, then the probate of the will is required, even when there's a will. Next, when we don't have a will, we rely on inheritance laws as applicable to that particular religion or community. For example, in India, we have Hindu Succession Act, Indian Succession Act, which have differences. And they don't talk about digital assets at all. On the other domain, the Information Technology Act was pronounced in year 2000. Of course, it has gone through amendments 2009 and subsequently many of this. There again, if you see, wills are excluded from equivalence of an electronic document. Wills, power of attorney, these are some documents which they don't accept electronic records. And the Information Technology Act is not even touched upon the subject of digital assets. And Inheritance Acts, as old they have not talked about digital assets. How do we handle? Even a mobile phone, after our death, what happens to that mobile phone? Because to get a new mobile phone, there's a process, there's an identification process, all that. And in the interim between transferring of even physical assets and movable and immovable assets, and the process it happens, there's a time gap. You need a death certificate, you need a notarization, you need to submit to the authorities. And then in the interim, because of digital age, if somebody makes a cyber fraud on that, either maybe money is taken away or some fraud happens, or somebody uses that email and sends some derogatory messages, then who is responsible? Does the estate of the testator responsible for it? They will hold that responsible. Another dimension which is complex is when you have these digital assets, we are talking about in the parlance of digital fiduciaries. Whether you can designate somebody through the will, saying that so and so will be my representative to deal with all digital assets. All means we have to itemize whether it is only the accounts or my assets which are in digital form. What happens to Bitcoin which is there in testator's name and the person dies? I don't know what the settlement procedure of a Bitcoin organization in case of a death. India is also thinking of coming up with a cryptocurrency of its own, but these are some issues. It's as good as cash with me in my wallet. At the time of my death, if somebody finds that wallet, takes away, that currency note is gone. I cannot give this thing. So in cryptocurrency, how do we handle all these digital assets? The complexity is in terms of identifying which are my digital assets. Second is who are the right people who can handle these transition to beneficiary, the executor as we call it in a will, or a trust. Trust instrument is not so much used in India, but it is definitely more used in the US and other places. Then we have executor 1, executor 2, depending on what it is. Then can we create a power of attorney within the will? But in India, power of attorney becomes invalid or void after the death of the person who is giving the power of attorney. Even in physical this thing, if you have a GPA and the person dies and the property has to be transferred, that POA is no more valid. I had a client who had a power of attorney issued by her sister who was based in Canada. Half the transaction is done, the agreement to sale of an apartment was done, and then the money, advance money was taken and remitted to the Canadian beneficiary. Since there is normally 3 to 4 months, the buyer takes time. After second month, the person who owns the apartment dies in Canada, in a non-English speaking territory. Then they have to get the death certificate translated, do that translation in English, then get that validated. Then as per the will, that property was bequeathed to 2 sons. This power of attorney holder, who is her brother, this power of attorney has become invalid. The new buyer is asking, I have paid you 50 lakhs of rupees, when do you register the property to me? Now those 2 children who are the sons are busy in their own work, they can't come to India in the short term. Then you need Aadhaar, then you need PAN, because there is TDS to be done. The transaction to complete almost took more than 1 year, so that they had to come here. Then that one of the brother has to give power of attorney to the other brother has to come register that power of attorney in the local courts. Then they have to complete the transaction, get the repatriation, then they pay TDS here, whatever, 22.5 or odd percent. Why I am illustrating is, even in a physical asset, when there is so much is involved, imagine if we have really valuable digital assets. Today, if you go to a digital world, you can buy digital real estate. Actual money, you are talking about $500,000, $1 million kind of multiple dollars, millions of dollars involved. So how do we transition this kind of digital assets? Some may be having that, some may be having other aspects, but also if you don't do transition of that asset, you may carry a liability of potential frauds, potential crimes that may be created using that digital asset of the person. So my submission to all my clients, which I tell is, you please make a will first and foremost. Include all types of assets, including digital assets, including emails, even as simple as email, Facebook account, whatever that is. Or if you are not planning to use, formally close such accounts. You can close that and you can take all your data, do whatever you want. Or in some of the service providers of the digital world, they have, some of them gives a provision saying that whom do you want certain things, rights to be given post the death of the person. They may at best, either you can say only header data, that means all contacts and things like that, not the contents of the email, contents of the Facebook pages, etc. That varies from service provider to service provider. You have to go to the terms of service, then select for what it is, then you can designate somebody. In some of them say, okay, give both content and the header information, all that, but then all these needs to be communicated back to the service provider in a format and a forum acceptable to them. Suppose that happens in Bangalore, I had to send it to California. We have to understand whom all that also it is better to be listed in the will, otherwise the beneficiaries may or may not know where to go, how to go about it. This is the important aspect. Then the other one is, do you store user ID and passwords? Passwords keeps changing. Some service provider says every 30 days, every 20 days, you have this thing, or somebody says use our grid. For some things you have to use the grid, something you have to use the OTP, some other access codes will be there. That keeps changing. And how do you communicate this? Do you keep a sealed envelope as part of the will and then tell in the will saying that this sealed envelope to be given to so and so for all my digital assets, I have given instructions? Is this possible? These are the issues that we need to ponder upon But as much as we can do, even when we don't have legislation, there are certain constructs in the will which we can add additionally for digital assets. Apart from itemizing and inventory, I can list down at least this is my email account 1, email account 2, email account 3. This is what I have used. I may not put the password there, but that I may put it in a sealed envelope and keep it along with the will. That at least somebody can do. Or request for reset. Sooner that is done, that is better, or the beneficiary. That fiduciary of digital assets need to know technologically saying how to go about it. And in that sealed envelope, it may be also better to state who are the people that needs to be contacted for digital assets. If you want to say, I have this digital trademark artwork I have created, this I want to assign or transfer to so and so. This copyright book I have written may be published, may not be published, yet I want to give it to so and so. It has monetary value. Suppose somebody is running a web services. I am running a, let us say, tutoring on legal topics. I want to, let's say it's a paid subscription for every hour somebody pays. So what happens to all that? So at that time I say, okay, somebody else will continue, he can take over. So we need to identify the beneficiaries even for digital assets. Then there are innumerable number of, even barring the cryptocurrency, today I am sure we have Metro card, we have so many such cards, e-wallets, IRCTC, there will be money in that, may not be very big, but still you will have. You have virtual accounts, virtual credit cards. So we have to make sure for two reasons. One is it gets bequeathed to the right person. Second is that one doesn't get into any fraudulent activities of that, so that an action is taken immediately on the death of the testator. And the other dimension that we want the parliamentarians and lawmakers to look at is this digital asset transfer. What are the regulations that need to prevail upon along with the existing inheritance laws? One is when there is no will at all, what should happen to the digital assets of the testator? There is no clarity in the current regulations that we have. Though of course some judges may say, I will use the existing inheritance, I will interpret suitably into that. But again, judges also needs to be educated the intricacies of these digital assets and digital implications of these digital assets. What are some of the things that has happened? In one case in the US, Yahoo, two brothers, one of the brother helps the other brother to create a Yahoo account. That brother has been using the account and he has been using the email. That brother dies. Now, as per his will, the estate is to be managed by the other brother and one more sister. Now, these two, as the estate executor of the estate, applies to Yahoo saying that give me all the contact numbers, we want to inform them of the death of my brother John. First, Yahoo says, no, we can't give, etc. It goes into a court in Massachusetts and they say this and that. There again, as you know, in the US, many state laws are different than federal laws, may be there, may not be there for everything, and there will be variations. Then the Massachusetts court judge says, no, this belongs to Yahoo, which is in California, so you have to go and file this petition in the California court. They apply for a summary judgment and all, but the court says, no, the Yahoo says, I can't give anything. That's a first position. Then the court says you have to give the header information. Then the brother, one of the co-owner, he says, I am a co-owner, I need to get that access. No, sorry, he is an independent user. You may be a joint account creator, but you don't have access to the contents of the brother. This goes on and on for quite some time. Even now, they have not given the contents of the mail. So these are the challenges that prevails when we talk about digital assets. Digital currency is another thing which I am not going to go too much. But again, digital currency, if you have, how do you transfer that to successors? Then of course there is one regulation which US has tried to bring in called Revised Uniform Fiduciary Access to Digital Assets Act. Just to give a context, in US, while the regulations may be made, the adaptation of that varies from state to state. They may adopt, they may not adopt. Maybe about 50% of the states have adopted as of now, based on my knowledge. The others are still needs to cover that, which talks about a fiduciary access. You can designate a fiduciary access as part of the will, who can have access to all the digital assets of the person who has made the will. That you can also mention in the US context, the trust, whether it's New Jersey or California, this trust instrument is quite popular there because of the ease of transfer of assets, bequeath on the death of the testator. India, we don't have that kind of a regulation yet. Maybe it is time that we have to look at. Then awareness and education to the common public. How does one government go about saying that these are, because by the time it goes into that, the person who is the owner of the assets is no more. Unfortunately, he can't come and tell, I meant it this. That's the biggest challenge even in a normal will. How do you prove that was the intention of the testator? That is why we talk about executor, then we talk about the witnesses. Today, if you want to register a will in the sub-register office close by here, the testator has to come in person, the witnesses has to come in person, they have to sign, they have to scan. Then there is another question which comes saying that if the will has to be registered and the registrar has to see what happens to the confidentiality of the information. More so in the digital world, are you exposing too much? This is another balancing act. Privacy on one aspect, confidentiality, then need to be shown, need to be aware for the successors to own and take the benefit of that digital assets. While there are few steps which I wrote in one article about few years ago when I was pursuing my LLM in Los Angeles, I wrote this article which got published. Even in a simple thing, first and foremost is do an inventory of all the digital assets. Create this thing. As and when you delete or you have closed the account, update it as much as we can keep doing it. For any other physical assets, bank accounts, etc. Second is note down the as much as we say we can't write it down, do all that, but for our own benefit, we may have to do this, put it in a secret envelope, seal it, and then say this needs to be given along with the will. That is the second step. Third is have this additional flexibility, additional statement in the will, what needs to be done to the digital assets. Even in the absence of anything in India at the moment, it is better to define what the testator wants to do with the digital assets. At least the testator has to be clear, saying that these are my assets, I would like to get transferred so and so. Then I'll just read an authorization for release of electronically stored information. One of the possible clauses that can be included in a will. I hereby authorize any person or entity that possesses, custodies or controls any electronically stored information of mine, or that provides to me an electronic communication service, which also includes all the internet banking and all the various things, or remote computing service, whether public or private, to divulge to my then acting fiduciaries at any time any electronically stored information of mine, that contents of any communication that is in electronic storage by that service or that is carried or monitored on that service, and 3. Any record or other information pertaining to me with respect to that service. The terms used in this authorization are to be construed as broadly as possible, and the term fiduciaries include an attorney in fact acting under a power of attorney document signed by me, a guardian, conservator appointed by me, or a trustee of my revocable trust or will, a personal representative, executor of my estate. This authorization is to be construed to be my lawful consent under the applicable laws, example USA laws, Electronic Communications Privacy Act as amended, Computer Fraud and Abuse Act, etc., etc. Like this, at least the intent of the testator can be in written form. My objective is today to kind of highlight the criticality of today's need. Uh, it is not about the age at which you have to do this. I would feel at any age that needs to be done. Once somebody is a mature person, an adult as defined by the law, one needs to do. Today, even children will have assets. Suppose we see so many musical programs in the TV. Saregamapa, India Has Talent. So many youngsters come and sing. They all carry their IP on that. This is the important point. I would stop here. I just want to summarize our session, which is the first program on the Be Heard initiative of BIC. I want to thank the participants, but as I mentioned during the talk, the importance of creating digital assets as part of the will process is extremely important for everybody to make a will, including their digital assets. While the regulations and the implementation of those regulations may take some time, it is nevertheless extremely important to itemize all the digital assets, define the beneficiaries for these digital assets, and the mechanism of transmission of these assets to the beneficiaries, and define the fiduciaries for these digital assets, so that the fiduciaries who are knowledgeable in the digital world can interact with the service providers to get those digital assets transferred to the beneficiaries. As one of the thoughts, I feel there is a need for creating a digital trust services in India, who is an organization who has credibility and who can create such an infrastructure in the country where people can include their digital assets, the nominations, then the beneficiaries and the fiduciaries, and even if it is for a price, to be collected from the estate of the beneficiaries. This is still a worth and needs to be taken with further thoughts and possible implementation in the country. I once again thank you, all the participants and the BIC, for this opportunity. Thank you very much.